Good morning. It's Phil Anderson and welcome to the webinar this morning on estate planning. When we first saw the FACEA practice exam questions, we were quite surprised by the technical nature of them, and particularly the questions with respect to estate planning and enduring powers of attorney. Our first response was to go back to FACEA and ask why they were so technical. But our second response was to identify the fact that estate planning is an important part of financial advice, and we recognise that it would be useful to put a webinar together to help members to gain a foundation understanding of estate planning. Now, the reality is that financial advisors do need to think about estate planning. Even at the most basic level, it's about identifying whether your client has a will, whether they have an enduring power of attorney. And if you get an answer back no, then it's absolutely about making sure that they go to an estate planning lawyer to get those put in place. Now, it may be that you're much more experienced and you're starting to play a much more active role in working with lawyers to achieve an estate planning outcome for your clients. So today we've organised a webinar. We've got Nicole Nobel from Fitzpatrick Estate Lawyers to present to us this morning. So I'm going to pass over to Nicole right now, but we'll be staying involved with the webinar, and we've got time at the end to consider questions, so we invite you to put any questions forward. Thank you, Nicole.
Thank you very much, Phil, and a big thank you to Philip Hewen for this opportunity to speak to all of the members of the association. So Phil has mentioned that estate planning is my profession, but estate planning is also my passion. And why am I passionate about what I do? It's probably the same reason why you are passionate about what you do, because we have seen time and time again the real difference skillful advice can make to people's lives, and the devastating consequences of them not getting good advice, or worse still, no advice at all. So what we're speaking about today is estate planning. And hello to everyone from all over Australia. I understand that there are members from all over Australia who are listening to this webinar today. Thank you. We've got our slide there, the power of planning, getting planning right for your clients and you. And now we're talking. Here's the important disclaimer, which I'll invite you to read at your leisure, perhaps with a cup of tea before you go to bed. Please don't rely on any part of the contents of this presentation without first obtaining advice from a qualified professional person. So, what is estate planning? Well, basically it's the process of structuring your affairs during your lifetime to protect your asset base, legally minimise tax, make provisions for incapacity, and put in place strategies to pass wealth on death or incapacity securely and tax effectively to your intended beneficiaries. Essentially, it's the art of control and protection of family wealth down the generations in ways that avoid disputes and help reduce tax. Here's the fundamental principle that all we advisors need to live by. Unless the estate is reasonably simple, expert taxation, estate and financial planning advice should be considered. So why should we care about estate planning? Well, we're all in the business of providing advice in the best interests of our clients within the highest professional and ethical frameworks. What we do counts, and how we do it counts. So as financial advisors and as lawyers, we're all risk managers. We commit to acting in our clients' best interests. We analyse our clients' whole financial situation, including their family situation. And then we recommend ways to maximise opportunities and mediate risks within a well-structured financial plan through all the phases of build, grow, protect and hand on. It's no secret that we have an ageing client base. Greater longevity means greater opportunities for travel and enrichment, but greater longevity brings with it higher risks of mental incapacity. Here are two propositions I'll leave you with. It's never, ever in the client's best interests not to plan for incapacity or death, and it's never in our interests not to help our client future-proof the financial strategy we and they have worked so hard to develop. Here's a couple of key questions for your client. What if you lost capacity? Who would you trust to manage your affairs in your best interests? And the second question you might ask them is, do you care what happens to your wealth when you've finished using it? I can tell you they're going to answer, of course I do. I do care. And here's what I want to do with my wealth. Protect it, minimise tax legally, and then keep it in the family. And as the trusted advisor, you're the best person to explain to your client, look, this doesn't come about by wishful thinking. As the trusted advisor, you can alert your client to what they can do, why they need a specialist estate planner and a good estate plan, and you can alert them to the costs of doing nothing. Here's what an estate plan, a good one, looks like. First of all, it should create an ordered, secure, yet flexible overall regime for the client's affairs for the present and the future. It should be simple to operate and not unreasonably expensive to maintain. Now, there are three key parts to the plan: the enduring power of attorney, medical guardianship arrangements, and the will. The enduring power of attorney is often overlooked, and it's so vital for your client. It empowers the attorney to manage the client's financial affairs in their best interests, even if your client loses capacity. The enduring guardian, or substitute decision maker, as it's called in some jurisdictions in Australia, makes decisions in your client's best interests about their medical care, including end-of-life wishes. Of course, the will. The will is an integral part of the plan. It should not be drafted in isolation from the other parts. The will should consider and include testamentary discretionary trusts, where the family wish to have tax-effective benefits, or there's a need to protect and preserve estate assets. I don't know anyone who complains about saving tax. No one. Flexibility is very important. Why does the plan have to be flexible? Well, none of us knows what's going to happen this afternoon, tomorrow, or in 10 years' time. So the plan has to be flexible and adaptable so that it can cope with unforeseen and unforeseeable changes in circumstances. It needs to be tax-friendly, addressing the tax implications for the estate distribution and asset transfers, including income tax, capital gains tax, stamp duties, and super death benefit taxes. Most importantly, it needs to be properly funded, and it must consider the need for appropriate life and personal insurances. A good estate plan always recognises and takes proper account of obligations to and expectations of a range of beneficiaries and family members. The estate plan should, at every level, seek to reduce the potential for estate litigation. This is across the range of those three instruments I talked about. There can be litigation about powers of attorney, about medical guardianship, or about the will. Every time there's litigation, there are huge costs. So the plan should not create adverse effects which will impact on the intentions of the principal, and it shouldn't create adverse effects in terms of social security for anybody. So it's more than just a will. We've got here 11 issues still counting. I've spoken to you briefly about powers of attorney, enduring guardian, and wills. But an estate plan looks also at the proper exercise of powers of appointment regarding family trusts, looks at business succession agreements, appropriate superannuation death benefit nominations, appropriate insurance nominations. It ensures that the client's tax affairs are in order and will be in order when they no longer have need for their wealth, and that attendant on the will, there's a statement of reasons or objectives. The estate plan provides your client with the opportunity to give clear and unambiguous instructions to the executors about what they want to happen with their wealth when they no longer have need for it, and how they want it to be administered so that their intended beneficiaries are not hit with any wounding tax bill. The estate plan also looks at family succession agreements. Now, obviously, with all of these matters, an advisor with the right skills is crucial to have on your team and on your client's team. I want to introduce you to Janet. Your client, Janet, is a widow with 3 adult children, Sandra, Andrew and Michelle, and you're managing her very substantial assets and investments, including super. Despite your suggestions, Janet has refused to execute an enduring power of attorney or a will. You are waiting to see her to assist her renew her superannuation death benefit nomination, when suddenly Janet has a stroke and she will live with serious impairment for the rest of her life, unable to manage her affairs. So what happens next? Even though you're Janet's trusted advisor, you have absolutely no say in what happens next. The financial and investment strategy that you had so carefully crafted, that you had spent hours working with your client in their best interests to bring to fruition, that's now at an end. You've essentially lost a client. The State Administrative Tribunal steps in to appoint a financial manager to administer Janet's affairs. And this is very costly and time-consuming for the family. When Janet dies, no will, there's a statutory formula which determines who gets what. There's no benefit of testamentary trusts. Costly disputes may perhaps ensue between the 3 adult children. Here's a very, very important risk mitigation action for you and your client. If there is no power of attorney or will, no enduring power of attorney or will, you need to urge your client to execute both an enduring power of attorney and will as part of a full estate plan, covering those 11 items I described a couple of slides ago. Advise them to go to a specialist estate advisor. As the Nike mantra says, just do it. If there is a well-crafted will and enduring power of attorney, you keep your client and you go on to assist the family. I want to talk to you about general powers of attorney and enduring powers of attorney. Many of you may encounter in your practice, among your clients, somebody who comes to you with a general power of attorney. There is a very big difference between a general power of attorney and an enduring power of attorney. The enduring power of attorney operates in your client's lifetime, and it continues to be effective even if the client loses capacity. This must be the absolute first choice for any client. No one knows when they will lose capacity, and that's including very, very young folk, very young people. A general power of attorney is generally used for a specific purpose. For instance, the client will be absent overseas and wants an attorney to act while they're away for a specific purpose. Liaise with the estate agent about an investment property. If the client loses capacity, under a general power of attorney, the attorney can no longer act. And here comes the State Administrative Tribunal again, or the Protective Office, who steps in to appoint a financial manager. So the suggested best option, or in my view, in our practice view, it's really the only option, is the enduring power of attorney, unless there's something for a very limited short-term purpose. What might a good enduring power of attorney look like? Well, often your client will appoint an attorney because they consider them trustworthy. It might be a family member. Because the attorney is trustworthy doesn't necessarily mean they're financially savvy. So uninformed decisions by even a well-meaning attorney can have unforeseen consequences. Clients can impose conditions or limit the powers of attorney within a power of attorney instrument. And clients may wish to consider a condition that prior to making substantial decisions, that is, they want to embed a condition in that power of attorney instrument, they want the attorney to take advice from suitably qualified financial advisors and accountants. The advantage of this is that this mitigates the risk that the attorney unwittingly upsets the investment and financial plan that, again, you have so carefully considered, worked on with your client. It's very important to know that if the client does embed such a condition, here you have the opportunity to be introduced to the attorney so that they know where to come to for assistance should the client, like Janet, lose capacity. I've got this form that you can't read on the slide, and why it's there for a specific purpose. Some of your clients might go and Google enduring power of attorney in whatever jurisdiction you're in. They might come up with what's a standard looking form. And you'll notice on that form, there's a lot of spaces. I appoint, etc. My name is John Smith, and I appoint Janet Smith to be my attorney. What I'd like to say to you is those standard forms, which are part of every the regime governing powers of attorney in any jurisdiction in Australia, in order to be meaningful, they need to consider many, many issues. We need to consider, for instance, digital assets. All of us work in a digital world. We have our financial accounts in a digital world. If your power of attorney instrument doesn't have in black and white authority for your attorney to manage your digital assets and digital financial accounts, all you need to do is embed it in the document, because if you don't have it, it's so important you don't have it in that power of attorney document, your client's attorney may encounter a very officious bank clerk who says, it's not in the document, sorry, you haven't got that power. Here are the other issues we need to consider. Superannuation, the ability for your attorney to deal with matters including binding death benefit nominations. We've already talked about a direction for the attorney to seek professional financial advice before taking substantial decisions. Also a good idea, a vital idea, to empower the attorney to have access to the will. I know in New South Wales, unless that's in black and white in the power of attorney instrument, no lawyer in New South Wales will provide a copy of the will to your attorney. The client may have a wish to give the attorney additional powers, such as the authority to give reasonable gifts and to confer benefits on the attorney or other family members to meet their reasonable living and medical expenses. You may wish to have a condition that the attorney, where acting as attorney and where practicable, doesn't do anything which is at odds with the client's ultimate intentions in the will. Let's go on to the wills now. Why are wills important? Why are effective wills important? I'll leave you to read the quote from Machiavelli. Men sooner forget the death of their father than the loss of their inheritance. Loss of an inheritance is a very, very painful event with lifetime consequences for many. And here is my colleague Mike Fitzpatrick in Roman Emperor form. Unchecked, one speck of sibling rivalry can turn into a volcano of estate disputation. Effective wills matter for the following reasons. Clients usually don't want a will from the grave, but they do want to keep the in-laws out. They want to protect family wealth from creditors and predators. They want to legally minimise taxation. And they want to pass control of multi-generation structures in an orderly way. That is, trusts often embedding ethical and values-based legacies. Effective wills matter because they put in place crisis provisions, protection for beneficiaries when things go wrong. They also provide sensitive and practical protection for the young, the vulnerable and the weak. Effective wills can corral any opportunity for estate disputation. So when you advise your client before a problem arises or alert them to a potential problem, this is the most cost-effective way forward. You don't want them spending money or their family spending money on estate disputation because the will has been very poorly drafted. Effective wills also establish a family office or family advisory board where the client affairs are complex. And effective wills can put in place effective philanthropy. Why might we consider testamentary trusts as part of an effective will? Well, testamentary trusts are the best vehicle after superannuation for protecting wealth. Testamentary trusts are created by will, and if properly drafted, optional discretionary testamentary trusts provide asset protection, care and maintenance of incapacitated beneficiaries, flexibility, effective intergenerational wealth transfer, confidentiality, and what I've got asterisk there is the special disability trusts which can be created under a will, which may assist in avoiding loss of benefits in the social security regime. One thing I want to emphasise is testamentary trusts are not a substitute for effective estate planning. Timely estate planning, considering all of the issues impacting on the family now and what may happen in the future, is essential. And when they're included, it's a requirement for you and your client to seek the advice of specialists in this area because special skills are required in drafting trust provisions in wills. Let's have a look at the 4 unknowns for your client and for you and for me. No one knows the date of their death. No one knows what assets they will hold when that time comes. No one knows the circumstances of their beneficiaries at that time. And no one knows what the applicable tax laws, and I might say what the applicable social security framework will be when your client no longer has use for their wealth. I'd like to introduce you to Joe now. Joe is your client. He's a very, very successful market gardener, and he's got 3 daughters, Stella, Maria, and Anna. He owns 3 investment properties. As each daughter gets married, he's a very generous man. He gives them a house. And when the houses are transferred, Joe pays the stamp duty and the capital gains tax on each transfer. Stella, the eldest daughter, marries well before the others. When Joe transferred the house to Stella, it was worth $700,000. It was a little tiny terrace right at the bottom of Paddington in New South Wales, and then the market exploded. That house is now worth $4 million, and Stella is going through a divorce. This house is front and centre in the family law court battle. Maria, the second daughter. The husband of Maria persuaded Maria to sell her house and put the whole of the bounty from that sale into their restaurant business, and the business went bust. The third daughter, Anna, kept her house And she actually improved it, but the house was worth nowhere near the value of the other two. 10 years later, Joe, your client, is terminally ill. Maria, who went broke, wants another bite of the cherry. The eldest, Stella, complains, I can't help it if my marriage failed, Dad. The younger, Anna, says, it's not fair. The house I got wasn't worth as much as the other two. Joe says to you, look, I want to sort this out, but it's too late. Joe's simple strategy of helping the girls has gone pear-shaped. All the daughters are contesting, no one's happy. Joe has wasted huge dollars on stamp duty and CGT with his lifetime gifts. And here's the moral. Don't advocate to your clients that they should give away their wealth while they are still alive. If your client wants to help their kids, lend it to them. We can learn a lot more from Joe, and that is that the most cost and tax effective way to pass on wealth is on your death. No stamp duty or CGT is triggered, no disposal. A gift in a will of a particular property is something you want to avoid. Lifetime financial gifts to children should be documented as loans. In an effective will, we'd have a hodgepodge or equalisation clause. Now, what does this mean? It means what it says. Your client instructs the executor to make sure that the division of the estate is equal across the three, in this case, three daughters. Why do you need an equalisation clause? Because each of his properties has a different value. Now, the ladies would inherit the cost base from the old man. The best way to transfer is make a gift in a will to the children via carefully drafted testamentary trusts. But the best approach in Joe's situation would be to divide his estate into three and let the daughters sort it out when he passes. Now, this doesn't mean that the daughters fight it out, because in a carefully drafted will, in an asset protective and tax effective will, there would be a direction to the executor for the executor to seek the advice of suitably qualified financial advisors, tax advisors, and estate advisors to ensure that the distribution of the estate is done in the most tax effective and asset protective way possible. A carefully drafted will would have, as part of the instructions to executors, your client's preferred financial advisor, your client's preferred tax accountant, and your client's preferred lawyer to assist in the effective administration of the estate. Once again, while an attorney is appointed because they're trustworthy, it doesn't mean they're financially savvy. Once again, while executors are often appointed by your clients because it's 2 children in the family or the 3 children in the family, very, very close friends, it means they're trustworthy but not necessarily financially savvy. And so if in an effectively drafted will, they are directed to seek advice from you, the financial advisor, from the tax accountant, from the suitably qualified estate lawyer, you know and your client knows that the distribution of that estate is going to be done in the most cost-effective and dispute-immune way possible. Here's something we call tiger country. If any of your clients come to you with any of these features of their financial situation or their family situation, you really do need to call in the experts, most definitely. We're talking about second and subsequent marriages, blended families, where wealth is held in family discretionary trusts, where there are complex business and trading structures, where there are self-managed super funds, when there are at-risk business people and professionals. And quite frankly, these days, everybody is an at-risk business person or a professional. Whether you're a builder, a nurse, a teacher, an accountant, an advisor, a designer, whatever you are, we are all subject to suit. Here's another red flag. If there are disabled or vulnerable beneficiaries, vulnerable beneficiaries are those who might be totally improvident spendthrifts. You've done your best to educate your children in prudent financial management, but they still want to go on overseas trips rather than settling down. Daughter might want to invest in Louis Vuitton handbags, but these are vulnerable beneficiaries and you want to protect your assets until they are considered responsible enough to receive your bounty. Effective wills can do that. There might be assets overseas held by your client. The family may be in dispute. There may be business succession issues. And there may be significant investment portfolios. All of these require experts to advise in the drafting of the will to put your client in the best place for the very orderly transfer of their wealth to their intended beneficiaries. What's your role in all of this? Well, it's a very, very significant role. As the financial advisor, you are both the front-end advisor to your client. You have a lot of time with your client and you see your client on an ongoing basis in developing their financial plan, in reviewing their financial plan. You're the front-end advisor. You're the first person that they're going to pick up the phone to if they've got a problem. You are also the centre of influence for the estate plan. That is, you'll be working in conjunction with other professional advisors, including insurance risk advisors, banking, and legal advisors. Secondly, you're advisors to the executors of a deceased estate or a family trust after the client has died. Involving all of the professional advisors at the appropriate time and for the appropriate purpose is critical. As to is the coordination of their service, the coordination of their service delivery, and maintaining open and frequent and honest communication between the advisors. Ensuring that all of this is achieved, your client will, in a practical sense, fall to either the lawyer or the financial advisor. In my experience, it usually falls to the financial advisor. That's the first person they're going to pick up the phone to. And then you'll be involved in coordinating the contacts with the other advisors. The better relationship between the financial advisor and the lawyer, the more likely the estate can be effectively managed and cost-effectively administered. Here's another vital role you play, and in my professional experience, I have seen members of your profession behave in an exemplary way, in a very, very sensitive way when these events occur. The role of the financial advisor after the client passes away is to protect and guide the surviving spouse, to establish, to assist in establishing and administering the testamentary trusts, to provide advice as to the tax implications associated with estate distribution, and also to act as a trusted sounding board for the beneficiaries. You in particular will be maintaining records and attending to all aspects of tax compliance with a tax accountant. You may well be assisting in the sale of business and investment assets. I have seen this time and time again where the husband may be the forerunner in a family business and his wife, his widow, does not wish to continue that family business. So you've got two lots of grief here. You've got the grief of the loss of the husband, and then you've got the uncertainty about the family business and the way forward. And that's where the financial advisor really comes into their own in assisting family. You'll also be counselling beneficiaries and assist in mediating any friction points. Now, that's not solving any friction points. That's not stepping into the role of a lawyer, but it's calming people down. It's letting the beneficiaries, the children of your client know, look, everything is in hand. It's all under control, and your dad or your mum have put in place a very good, well-crafted will so that it's going to be a very orderly transfer to all of the beneficiaries. You'll be actively collaborating with other financial advisors, that's tax accountants, and legal advisors, insurers, and you'll be professionally participating in a financial advisory board where the matters are complex. Here's a final word on wills. The modern will drafter is a solicitor who needs to be equipped with specialist skills, with advanced drafting abilities, together with specialist tax, superannuation and trust law skills. So you really do need to look for the experts. The need for collaboration with other professionals is crucial. A simple will rarely provides tax saving or asset protection benefits. You can direct control of the will and reduce taxation by legally applying a combination of strategies. When we're talking about assets held in family trusts, you really can never underestimate the importance of comprehensive and expert estate and financial advice. And this is before your client passes away. This is in the process of planning, conferring with experts in law, tax, and of course, bringing your own insights into the family situation, into the whole mix of how the advice is to be given. You have to make sure that the executors know where to go for advice and where to get it. And that's why we recommend a direction in a will which doesn't leave the executor floundering. It gives the executor the confidence that they are not on the journey of executor alone, that they can confer with their mum or dads or brothers, financial advisor, they can confer with their mum or dad's or brother's tax accountant, and they can confer with a family lawyer. Regular review of a will is crucial. We want to ensure, however, that when we draft a will, it is done to be future-proofed as possible. Simple wills often give rise to beneficiary complaint and litigation when their tax and asset protection shortcomings become obvious. So, how can you and I plan ahead with and for your clients? We all need to plan for incapacity and death. for our clients and ourselves. Death or decision-making incapacity without a good estate plan makes managing your client's affairs costly and time-consuming, both for you and the client's family and the client. You need to encourage your clients to get advice from specialists in estate planning and succession law who will work with you to assist your client. It's essential, by the way, that you connect with a lawyer with whom you can work, with whom you can really have trust and confidence, so that all of your clients get a similar standard of service. As advisors working together, we're in the very best position to assist our clients while they have capacity, with ways to prevent unforeseen problems. Again, if there's no enduring power of attorney or will in place, you keep faith with your client. You're embedding yourself as the trusted advisor by directing them to a specialist estate lawyer to get them executed, to get the documents executed. If there is, however, an enduring power of attorney or will in place, and your client has in that power of attorney a direction that the attorney take advice from their preferred financial and tax advisors, you keep your client. Your role as the trusted advisor continues as you deal with any events affecting your client, and ultimately, you're involved in the administration of the estate. Your client has the peace of mind knowing that whatever happens, their affairs are going to be in good hands. That's it. Thank you.
Fantastic. Thank you, Nicole. We're certainly open to questions, and we do have some questions. I'd like to put one question to you at the outset. You spoke at length about the issues with a client losing capacity and not having an enduring power of attorney. How is incapacity formally assessed, and are there things that advisors should be conscious of in dealing with older clients who may be at risk?
This is a whole other seminar. This is something that as lawyers we are very alert to. And I believe that I'm not going to be able to answer this in 1 or 2 minutes. There are 3 basic ways you can move forward. One is to have an assessment by a specialist. Let's say we're talking about an elderly client, and you've met the client and you've been working with the client for 10, 15, 20 years, and they're as sharp as a tack. One of them might be a former ATO advisor. Brilliant. And you notice when you're meeting with them for an annual review that they just don't seem to be on the ball as they always have been. At that point, you raise the issue with them, asking them about have they had any health concerns lately. If you've got a concern about their capacity to deal with you and to fully understand your recommendations, if you've got a doubt, proceeding with that client is not advisable. That's one thing. If the client has an enduring power of attorney in place and prudently the client has introduced you to the attorney for this very reason, you can speak to the attorney with the client's permission, of course. You would need to explore it further. Sometimes capacity can be a waxing and waning event. If your client has had recent surgery, what we know is that the effects of anaesthesia can be with us for 5 to 10 days afterwards. So you'd have to look at the whole context that your client is in. Obviously, as lawyers, we do have very comprehensive ways to approach this, and I'm happy to give your members further advice through an email.
Fantastic, Nicole. Look, I thought that puts it in context that it's not a simple issue, but it is something that advisors do need to be very conscious of, because if they are providing advice to someone who they believe there is a question as to whether they've got lost capacity, then they need to be particularly careful. Okay, we have a question from Neil. Does a superannuation proceeds trust have to be specifically noted in the testamentary trust provisions in the will?
That's an excellent question. In the approach that we use, because we don't know what the future holds, we absolutely do not know what the future holds. We don't know the circumstances of the client, and we don't know the circumstances of the beneficiary when the client passes away. So we recommend in our approach a list of every possible type of optional discretionary testamentary trust you can think of. Proceeds of super trust, Veterans Affairs Trust, Special Disability Trust, a whole variety, so that if at the time that your client passes away, there's a need to establish a proceeds of super trust, the authority for that is already in the will. That's what I call the prudent, careful, well-considered approach to will drafting. Leave nothing to chance. Leave nothing to chance.
And obviously that's the other important thing about wills, in that superannuation, insurance and other assets are not necessarily, aren't dealt with through the will.
Yes.
That's the critical point there. Okay, we have a question from Peter. And some of these questions demonstrate a level of knowledge that they are very familiar. What powers does the donee have as an enduring power of attorney regarding clients' roles as director, trustee, appointer and guardian?
Now, this must be from a member in South Australia, perhaps?
I can't be sure. Peter, maybe you can let us know.
Because it is a particular feature of South Australia that we talk about the donee of the power, but it's a technical term. Now, if you have a carefully drafted enduring power of attorney, in reference to any of the vehicles that your client holds their wealth in, you can make overt a direction in the power of attorney, provided your client so instructs, to allow the attorney to make certain decisions in those vehicles, in relation to those vehicles. So it has to be overt. If something's important, it has to be black and white, and it has to be in the power of attorney. An attorney, by the way, has very, very full powers. Behind a power of attorney instrument, you've got a whole body of general law, and you've got a whole body of judicial decisions behind the law applicable to a power of attorney. Now, what you want to ensure is that your client is not relying on an instrument, the one that I showed you, that they've pulled off the net somewhere and it's just been filled in to dispatch the client quickly. You want to ensure that you have, as the lawyer, and this is where the relationship with the financial advisor is so vital, an absolutely comprehensive understanding of your client's financial arrangements, the vehicles where they hold the wealth, family trusts, businesses, and it's incumbent upon the lawyer to review all trust deeds for self-managed superannuation funds, family trusts, any vehicle that your client holds their wealth in. It's incumbent upon the lawyer to review that. review all the insurance arrangements, for instance, insurance policies, binding death benefit nominations, anything that your client is involved in is incumbent upon the lawyer to review all of those.
Great, and Peter was from WA.
Oh, hello, Peter. My grandmother's from WA.
And we have another question clearly from WA. An engaged WA audience. Is an EPA established in WA valid Australia-wide, and what about overseas? Secondly, if someone is currently based overseas, travelling, temporarily working over there, can they establish an EPA in Australia?
Let's take that one at a time. As we know, so this is the question, is the power of attorney valid? Let's say there's a power of attorney drafted in Western Australia and you want to know whether it's applicable Australia-wide. Australia being the wonderful, diverse federation it is, the laws governing powers of attorney are different in every state and territory in Australia. Now, it is common for people to hold properties, let's say in New South Wales. I'll talk about New South Wales. Someone lives in New South Wales, it's me, I want to buy my grandmother's home in Subiaco. If I have a power of attorney in place in New South Wales and I want to deal with real estate in Western Australia, it's probably prudent that I have a power of attorney under the legislation applicable in Western Australia, as well as the power of attorney in New South Wales. This is just to avoid stumbling blocks. This is just to avoid Land and Property Information Services saying, no, I don't recognise this. On the whole, there is a conventional acceptance of a power of attorney across the jurisdictions, unless somebody says, no, I won't accept it. So in that case, it would be prudent to have them, particularly when we're talking about real estate, it would be prudent to have the enduring power of attorney in New South Wales, and then a power for a specific purpose. My situation, enduring power of attorney in New South Wales, but a power of attorney for a specific purpose in Western Australia for the acquisition of a property there. But I will give you further detail on that. I can give you 2 pages on that. And the second question.
So I think, the message there is if you've got assets in 2 jurisdictions, yes, it may make sense. But I think the second part of it is for someone temporarily overseas.
Yes. So this occurs very frequently. If they're temporarily overseas, here's what you can do. It's always wise, first of all, it's always wise to have an enduring power of attorney in place in the jurisdiction where you live. The person you appoint as your enduring power of attorney, that's the person who's going to be looking after your affairs should you lose capacity, mightn't be the person that you appoint for a specific purpose. So one of your clients is overseas for 6 weeks and they want somebody to look after their investment property while they're away in case the tenant floods the property or something like that. You might, in that circumstance, put in place a general power of attorney, or it might be something as simple as you need to get, your client needs to get their tax return in, but they're going to be overseas. A family member has passed away overseas, they're going to be overseas. So in that instance, your client might, in that instance, appoint their lawyer to be the attorney for that specific purpose, sign off on the tax return.
Great. Okay, another question. Quite often parents want to help out their children while they are still alive and their children are at a financially needy time in their life. You mentioned you're not in favour of giving away assets while alive. Should you give all children the same amount if possible? How do you handle a loan in the will?
we're all in this situation. And as we know, children are living in the family home longer and longer. No one in my circle has a child who leaves home at 18 like I did and all my friends. They're still there in their mid-20s and some of them in their late 20s. So this is really, really, really the opportunity for the lawyer and the financial advisor to work together very closely with your client. I'll alert you to one thing only, which can happen if you give money to your child. If this is a question from Western Australia, you don't have the high rate of divorce that we have in New South Wales, but it was running at 50%. So if you give money to your child and the child marries and uses that money to purchase a home as part of the purchase of the family home, that money then becomes part of the pool of assets in any breakdown in that relationship. If you give money to your child on the basis of a loan, which is well documented, and you can put terms and conditions in that loan, that it is immediately repayable on demand or something like that, don't rely on this advice. Get a lawyer beside you when you're structuring loans between your client and their children. That money is quarantined from any breakdown in the relationship. That's one good reason. In terms of how we treat our children, that really is a personal decision for you. And nobody, unless they knew the entire circumstances of your family or your client's family, would give any advice on that. I talked about the situation with Joe and the 3 daughters, and we saw how that situation, Joe was so well-meaning. He was such a kind dad, and he wanted his girls to have the best start in life so that if they got married or when they got married, they had a roof over their head, the grandchildren would follow soon after. But he really caused huge problems. If he had held on to the wealth and he had a well-structured will with an equalisation strategy in the will at the time that he passed away, the estate, in his case, he was a very fair-minded guy. He wanted his legacy to be family harmony. He wanted all the girls to be together for Christmas and Easter with all the grandchildren. He didn't want any disputes. If he'd had an equalisation strategy in the will, there would have been a way of equalising out those gifts. And I'll actually tell you what we did with Joe. I think I may have it here. When he did very intentionally say that he wanted to pass the properties, we had valuations done for stamp duty purposes on each transfer. And then when Joe passed away, we went back to determine what the particular value for each property was. And then we made an adjustment for inflation at today's date. So what happened, it worked out that the eldest daughter, Stella, had received $400,000 more than the other 2 when everything was adjusted out. So we had the adjustment clause, the requirement for adjustments to be made in the will. And Joe had taken our advice on that, and so the matter was able to be resolved very, very effectively. Family harmony was preserved. There was an adjustment across the 3 girls, so they got equal. They got an equal amount. But what we do for our children is entirely up to us, but it's really, really wise to get good counsel and to reflect long and hard with our financial advisor and our estate planner. In my experience, it's a moment for the will maker to disclose to others in the strictest of confidence any concerns they may have about one or other child. One child they think might be improvident and another child very successful. What other forum do you get to talk about what's on your heart in terms of your children and their future and how you're going to be fair and just in handing on your wealth? What other forum can you have really impartial but sensitive advice on what decisions you might need to make in your own family?
Nicole, we have 2 more questions which we'll try and quickly cover. We are just about out of time. Neil said, what is your view on including a power for the state administrative tribunal or similar authority in other states to approve a power before it comes into effect, to appoint a secondary attorney if the primary cannot or won't accept, or for disputing family members?
This is a question of drafting. When you draft a power of attorney for your client, no matter what jurisdiction, and they're called different things in different places, by the way, to appoint one attorney only is very imprudent. Many people appoint their husband or their wife, and that's it. But wise counsel from a lawyer would explore all of the issues as to who would be the best person to appoint as the attorney, and then who would be best placed to be substitute attorney or substitute attorneys. We don't need to go as far as the suggestion you've made. If the power of attorney instrument has a direction to the attorney to seek financial, taxation, and indeed estate advice about before they take any substantial decision, that is a direction from the principal to the attorney, and the attorney has to act on it. The principal can limit the powers of the attorney as well. A principal may appoint one person or 2 people and may appoint them either jointly or jointly and severally. That's a medieval term for saying jointly and separately, so one can act in the absence of the other. But the attorney, the principal rather, can put a condition in that if it's a big spend, a spend over $10,000, $20,000, both the attorneys must act jointly and already within the framework of seeking advice from the preferred financial advisor and tax advisor where it's a substantial decision. The protective office or the arm of the relevant state administrative tribunal will step in if there's any case of dispute, but where the benefit of very careful use of that forum between the lawyer and the client is to tease out those matters. Would you appoint someone where there's going to be a dispute or a potential for a dispute? Would you appoint someone if one child lives, let's say that you're in Western Australia, you've got one child living in Western Australia and the other one living in Queensland, the person who's going to be the arms and legs for you in Western Australia, paying all the utilities bills if you lose capacity, is the person in situ in Western Australia. For big substantial decisions, you may include 2 children. You don't need to be fearful that if things don't work out between the 2 attorneys, there won't be a backstop. And you certainly don't have to embed recourse to the State Administrative Tribunal or a protective office, because that will happen under the law anyway if there's dispute.
That's certainly good guidance, and it does reinforce the point of regularly reviewing who the powers of attorney are as to whether they are still appropriate. Now, the last question we got was, How can advisors fit this within the framework of their service agreements in order to be remunerated for providing advice in this area? Which is probably more a question for me. And it's obviously important in the current environment that advisors are delivering the services that they commit to provide. And it comes back to how frequently you're going to be doing reviews for your clients and the scope of the services. So you do need to make sure that you are always carefully checking that you have done what you've committed to doing, but it means that you need to make sure that estate planning remains a subject that is an integral part of each annual review.
May I just add something there?
Sure.
Working collaboratively with financial advisors, as I do, I am very respectful of the expertise of the financial advisor and the tax accountant. I never intrude into their expertise because they are offering financial and tax advice to your client. Similarly, it's very important that what is really in the domain of the lawyer remains in the domain of the lawyer. It's very important that we work together collaboratively so that an understanding of estate planning is vital for you, but actually doing the drafting of wills or involving yourself in trust documents, that really is in the domain of a lawyer. Does that make sense?
That's absolutely right. I mean, it's very important that advisors understand that their primary role, I mean, obviously we've got people who are very knowledgeable about it, but their primary role is to make sure that clients understand the needs for estate planning and that they get them in place.
Yes.
And that they get the right advisors to help clients to sort out all of those arrangements. And they need to be careful that they're not over-committing in terms of what services they can provide. Nicole, we'll wrap it up there. Look, I think that was a fantastic introduction to estate planning. I hope that everyone got a lot out of it, and in particular, that basic understanding of the importance of making sure that this is part of the dialogue they have with clients, and that where they see alarm bells, they respond. They don't let clients walk out the door without deciding to take action to deal with fundamental estate planning gaps. We will be sending out a survey to all participants afterwards to get their feedback. As part of that, we invite members to provide feedback on any other webinars that they would like to hear. We had well over 140 people on the call today, so I hope you've all got a great deal out of it. We will be providing CPD points for today, but I would like to once again thank Nicole for a very informed, very useful presentation. Thank you, Nicole.
Thanks. Before we go, I'd like to thank you all very, very much for your time and attention. It's a mark of the real efforts that you're making to be out there, be proud of your profession, understand that what you do counts and how you do it counts. And it's been my honour to work very collaboratively with members of your profession in a very, very satisfying way, a way that enhances our delivery of services to our clients in their best interests in the highest professional and ethical frameworks. So thank you very, very much for your time and attention.